button. So let's make sure the stream is alive and well before we get started on this very impromptu Saturday afternoon little broadcast we have here. Looks like we are live across the board. So let's go ahead and get started. Afternoon little broadcast we have here. Whoa. That shouldn't have been making that noise. All right, everybody. So hello, welcome. My name is Robert Gruler. Of course, I am a criminal defense attorney. Typically, I start the program by diving into a little bit of an introduction, talking about watching the watchers and the police and the prosecutors and all that stuff. But today, we are doing something a little bit different. We're doing an impromptu show about a digital bill of rights. This is something that we've been workshopping just a little bit on our daily show called Watching the Watchers Live, which of course is something that takes place every day of the week. We would love it if you joined us for that. And on the program, we've been responding a little bit to some of the activity that we've seen out there on the internet, in particular, some of the deplatforming, some of the censorship, some of the demonetization that's going on, and a lot of other issues. And so as we've been sorting through it, as we've been trying to figure out how to maybe respond to an evolving internet and an evolving environment, this idea came up about a digital bill of rights, something that we can revisit as a society in the new digital age. Many of our laws, like Section 230 and some of the other regulations surrounding the internet companies, were created back in the 90s. And a lot of things have changed since then. The internet has grown, it has evolved. The tech companies are now some of the biggest entities on the planet. And people are starting to ask themselves, is this the way we want to govern our internet life? Is this the way that we want our country to be governed or sort of managed by these different individual companies? And so what I've been doing is playing around with a digital bill of rights, sort of a new set of rights that we would discuss and implement for the new age. And so I really don't like a lot of videos that will tease you too much. So let me just give you a quick overview of what the 8 Bill of Rights or the 8 digital Bill of Rights that I've come up with. Then we're going to dive into it. I want to go a little bit deep on some of this stuff. So let's just get to the good stuff right away. This is the list that I've come up with. Now, this is just my opening thoughts, my opening ideas. So let's take a look at them. Number 1, of course, digital freedom of speech. Number 2, the right to digital personhood. Number 3, the right to deletion or removal, the right to information, the right to privacy, the right to unfilter, and I'm not real sure about this word, unfilter. I'm open to suggestions on that. Number 7, the right to due process. Number 8, good faith protections, and I'm going to explain what all of these are. Now, I was mirroring the current Bill of Rights that we have, which are the amendments 1 through 10. And so I don't have anything for amendments 9 and 10. Now, I know that these would be technically amendments 28 through 38 because we've got 27 amendments that are currently in our Constitution. But this would be, I'm open for some other thoughts. 4, 9, and 10 don't necessarily have to have 10, but it just feels good for synergy purposes. So this is just an opening argument for me, just some opening ideas. I have never drafted a Bill of Rights before. Might be surprising to some people, but I have never done so. And I understand that when I was drafting these, a lot of it was out of frustration. A lot of it was because me personally, as a content creator, has had some frustrations trying to navigate it. As a citizen, I've also had frustrations trying to participate in the conversations. I've had frustrations trying to receive information from certain individuals that I can no longer receive information from. And so it's sort of born out of my own frustrations. And I understand that there's going to be some implicit biases here, probably against some of the big tech companies, but I tried to balance that out. And so let me walk through a couple things that I think are important to understanding how I laid out the rest of these digital Bill of Rights, or the DBOR, as I'm calling them. So I want to just make sure that we as a community, that anybody who's thinking about playing in this space or brainstorming with some of these ideas, we're thinking about incentives. What kind of incentives would these rules create for the big tech companies? And more importantly, what are some of the perverse incentives that might be created here? We have to think through all of the different tentacles into the different facets that these rules might spill into. And it could be, more problematic than beneficial. And I'm drafting these with all of that in mind. And so here are just a couple of my thoughts. Here are some general frameworks on how I came up with this stuff. So number one, I wanted to use existing thinking. And what I mean by that is we already have a lot of laws on the book. We already have case law. We already have principles that we can refer to from the Federalist Papers, from the Anti-Federalist Papers, from the existing Bill of Rights. We've got an existing Constitution. We've got, thousands, millions, hundreds of thousands of court opinions that have already been drafted on a lot of these issues: free speech, free expression, free association. So we don't have to do a lot of thinking again. These are sort of tried and true issues that have been around since the birth of man. And all we can do is just sort of refer back to some of the tried and true principles. We don't need to recreate a whole bunch of complicated stuff. Next, I want to consider the internet as a whole. So under number two, the internet in its entirety as a whole. And when I use the word internet, I use it as sort of big I internet. I'm talking about the entirety of the internet as an organic, loosely defined entity, not singling out any one particular entity, not talking about Facebook or Google or YouTube or Stripe or Pinterest or any of those. Just as an organic thing, the internet has sort of blossomed to encompass a lot of different agencies, a lot of different companies, a lot of different voices, governments, everything into this one organic entity. We're calling that the internet. Now, the internet, the big I internet, is a power structure similar to the government, right? This general concept of the government. The government itself is this amalgamation. It's this consolidation of hundreds and thousands of different entities and agencies and different alphabet letters, and all these things make this one giant power structure. And so as we're talking through this, it's kind of a similar concept. The internet has a life of its own to a certain degree, much like the government does. And so while the original Bill of Rights was set in place to sort of restrict the government from encroaching on some of our fundamental basic civil liberties, we're trying to make that same argument here about the internet. And so I want to be clear, we're not trying to punish any particular entity, right? I'm not angry really with Jack Dorsey or Mark Zuckerberg or any of these people. We're just talking about this sort of phenomena of the internet that has bubbled up and evolved over my entire life. That is big I internet. And we're going to get into a concept of the public sphere and how the internet has sort of morphed into the current public sphere. But I just wanted to point that out, that we're talking about the internet as a whole. The next point is this concept of negative liberty versus active liberty. And this is a concept that you can really get into the weeds with some of this stuff. You can talk about active rights versus negative rights, negative liberty versus active liberty. But the general concept here, at least when I was drafting these, is not to be punitive to any of the internet companies, to the big I internet. Don't want to punish them. Don't want to mandate a bunch of rules and regulations that make it difficult for them to comply with. We're not going out there and saying, you have to build this software and open up this entity. We don't want them to balk at conforming to the regulations. We want to reward them for providing more free speech, more access, more expression, and less restrictions. If they operate according to those basic fundamental principles, then they're protected for that. It's not that they have to go and build all of these different systems. As long as they're just making things more free, more accessible, more expressive, then they're going to be protected as a result of that. We're also talking about simple construction of the rules. When I say simple construction, I'm talking about the drafting of the language. I've seen other proposals out there on the internet where it's, 5-10 pages of documents, and it is intended to be this big, long solution passed by legislation that once it's passed, we're going to know the ins and out of everything. Every single line of conduct is defined, and we know exactly what the rules and regulations are surrounding particular things and activities. That's not the goal here. What I'm trying to do is mirror our existing Bill of Rights, which, as I'm going to show you, is very simple. Couple sentences for most of the amendments. And what the sort of beauty in that is you lay out those fundamental principles, those key foundational issues, our liberties are defined there, and then the courts, the Congress, they codify in statute how it should be put into effect. The courts decide what is free speech. They decide what's not protected and what is protected. And so right now what we're just trying to do is lay out the basics, lay out the foundational stuff. I want it simple. I don't want big complicated things because it's hard to convince people. It's hard to be persuasive, which is the next bullet point, that this thing has to be persuasive. People need to understand this. If the goal here is to get this actually implemented, to get a congressperson to be able to take this up and detail it to their constituency and have them move this ball forward, whether it's through a constitutional amendment, which is the final bullet point, or a convention of the states, it has to be persuasive. Currently, right now, we're talking a lot about Section 230 and liability, and it just goes over the head of most people. And it's very difficult to understand, especially if you've got other Congress people who are 80 years old and they don't even use the internet. And they're trying to dictate how this stuff should work. And they're trying to bring in all of the big tech CEOs and ask them questions about a product, about a platform that they don't even know, that they don't even know how it works or how to use it. So this needs to be simple so that the constituencies can understand it. And when we talk about, Section 230 reform, people's eyes glaze over. They go, what the heck are you talking about? If you say, how about a digital bill of rights so that you don't get kicked off the platform, you are able to to post what you want, you can see the data that you want to see, you're not being censored, people can understand that. And I think the likelihood of it getting traction is much more available if it is persuasive and it's not just limited to Section 230 and those types of things. And then lastly, the goal here is mostly a thought experiment. We just want to go and kind of toy around with these ideas. I would love it if some of this stuff got implemented, but as I said, I am not somebody who is a lobbyist or a political activist. I like to sort of play around with thought ideas, and if we could create something that we could draft into a constitutional amendment with your help. I can't think through all this stuff on my own. I don't have the brain power to do it because it involves a lot of different aspects of life that I don't live in, right? I'm not part of a tech company, never worked for a tech company. I don't know what their pain points are and what difficulties they might have trying to comply with a new digital bill of rights. And we certainly don't want to eliminate Facebook or Google with draconian policies. We just want to make sure that the citizenry, the people who are, Americans who are non-Americans, people who want to be a part of the conversation, have the ability and the freedom to do that because of our inalienable rights that we've already defined in our current Bill of Rights. So a constitutional amendment would be great. We could set it up, so that we could draft the document, send it to a lot of different representatives and senators. They could formally introduce it, or we could present it at a convention of the states if that were to be something. So let's dive into it. Now, I want to get into some political theory, and I want to go back through and take a look at and sort of flesh out each one of those bullet points. Then we're going to get into the text of the digital Bill of Rights. So let's take a look at how the original Bill of Rights back in the 1700s was implemented and what some of the thought process was behind it. So if you just look on Wikipedia, very good articles actually about the Bill of Rights. The U.S. Bill of Rights, the first 10 amendments that were added to the U.S. Constitution, they were proposed from 1787 to 88, a debate over the ratification of the Constitution, long debate. We've talked about some of this here between the Anti-Federalists and the Federalists. The Bill of Rights amendments were added to the Constitution. They wanted specific guarantees of personal freedoms and rights. Specifically, they wanted it in there. They didn't want to just say, well, the government has some freedom to define these. They said, nope, we're not signing on to this thing unless it's clear. And it's specifically about clear limitations on the government's power in judicial and other proceedings, explicit declarations that all powers not specifically granted to the U.S. Congress are reserved for the states and the people. These concepts were codified and amendments were built upon earlier found in earlier documents. They were leaning on the Virginia Declaration of Rights in 1776, Northwest Ordinance in 1787, the English Bill of Rights, Magna Carta. James Madison, somebody who I've talked about a lot, Federalist 51 and others, who studied the deficiencies of the Constitution, pointed out and then crafted a series of corrected proposals. They originally were talking about 12 articles. They settled on 10. And it looks like they were some of them. Well, hold on. Okay, so Madison's proposed amendments included a provision to extend protection, and I wanted to make a point here that of incorporation. So the original Bill of Rights was originally drafted for just the federal government, and then once we had the 14th Amendment, of course, the first 10 amendments are the Bill of Rights, so 1 through 10 are the Bill of Rights. Then we had the 14th Amendment during the Reconstruction era after the Civil War, and what happened was we had an incorporation of those rights. So originally, the first 10 only applied to the federal government. If you were a state person and you said, hey, I want to exercise my Third Amendment privilege against quartering, the courts would have said, well, that doesn't apply to you. That's a federal protection. If your state wants to quarter somebody, they can. Now, what ended up happening practically is a lot of the states still, took the same principles in our federal constitution, our Bill of Rights, and implemented them at a state level. But what you would see is after the 14th Amendment was passed, an incorporation. So slowly the courts started to say, okay, yes, the Second Amendment also applies to the states. The First Amendment applies to the states, and so on, until most of the Bill of Rights have now been incorporated into the states. And so what I wanted to make the point about here is that it's limiting the government's power, right? That's what this was all about. It specifies, guarantees personal freedoms and rights just to limit the government's power. And anything that that's not defined in this is reserved back to the people. And Mike, the reason why I think this is so important is because the government is just this beast that will naturally gobble up more and more power. It's just the nature of bureaucracy. That's my opinion on how this stuff works. But once you get bureaucrats into power, it's very unlikely that they're going to give any of that up. And that's why you see time and time again, these small government conservatives, they get into power, and then suddenly they're passing more executive orders and spending more money than anybody else in the country. And you're going, wait a minute. Right, because they're in power and they're just consolidating a lot more power. And so what the founders were saying, all right, well, we got to be very clear here. The people have to be the counterbalance to the consolidation of power. The people have to be able to respond, protect their rights, and reserve that because the government is ever encroaching against them. Same type of thing is happening here with big tech, with the internet. And I'm not just saying big tech in meaning Facebook, Google, YouTube, Twitter. It's the internet, right? The internet is consolidating power. We see this all around us, just naturally speaking. Amazon runs most of the internet because of Amazon Web Services. Google runs most of the searches because of Google. They're good at it. And they've consolidated their power. Facebook basically runs social media. They own Instagram. They own WhatsApp. Then you've got Twitter, which is really the main place that the political conversation is happening. So it's the same concept. The people have to protect themselves and guard themselves against the burgeoning power that just tends to consolidate itself, whether it's the government or whether it's big I internet, whether it's this concept of this organic entity, which is almost like a pseudo government in a way, right? They're very closely connected. They are centralizing conversations around the big I internet. They're all taking place there. And so we need to protect the people's interests by just making sure that we're checking these big power structures, whether it's the government, whether it's the internet, whether it's the military, whether it's the healthcare industry. These are pillars of power. And so there are times in our country where we have considered this. We said, okay, we have to modify how we're going to respond, and we want to provide more people with more civil rights. This has been a conversation that we've been having in this country for a very long time. You can go back and look at all of the civil rights that we've had. Let's take a look at civil rights. What do they mean? What are we talking about here? This was posted over on Britannica, which is an encyclopedic website written by Rebecca Hamlin. She's an assistant professor of political science, Grinnell College, Iowa. She contributed an article on civil rights, and I have a highlight here from her. Examples of civil rights include the right to vote. Okay, that didn't exist for everybody when this country was founded. Women didn't have it. African Americans didn't have it. The right to a fair trial, the right to government services, the right to public education, the right to use public facilities. As our country evolved, we extended more rights. Civil rights are an essential component of democracy. When individuals are being denied opportunities to participate in political society, they are being denied their civil rights. In contrast to civil liberties, you can get into the weeds here with some of this terminology, which are freedoms that are secured by placing restraints on the government, civil rights are secured by positive government action, often in the form of legislation. Civil rights laws attempt to guarantee full and equal citizenship for people who have traditionally been discriminated against on the basis of some group characteristic. When the enforcement of civil rights is found by many to be inadequate, a civil rights movement may emerge in order to call for equal application of the laws without discrimination. Right? And this has happened many, many times. We still are working through a lot of this stuff. In the Obergefell case, we just had Same-sex marriage legalized. That is a new right. And they didn't frame it that way. They're not saying that this was already existing. They're just recognizing it now. And we've seen this constant movement. And so we can have a conversation about this. What about digitally? Where we're spending a lot of our time, as I'm going to get to. This is not a new idea. Wikipedia has a list of many other organizations who've also talked about Bill of Rights. We've got a Consumer Bill of Rights, a Homeless Bill of Rights, somebody was drafting, Taxpayer Bill of Rights, Academic Bill of Rights, Veterans Bill of Rights, GI, Homosexual Bill of Rights, Library Bill, Environmental Bill of Rights, Creators Bill of Rights for comic writers and artists, they've got one, Donors Bill of Rights for philanthropic donors, law enforcement officers, they have theirs, California Voters, Islamic Bill of Rights for women in the mosque, New Jersey Anti-Bullying Bill of Rights, credit card holders, sexual assault survivors Bill of Rights. But these were all listed on Wikipedia. There's nothing there for the digital Bill of Rights, not on there. And there's pretty good evidence, I think there's a good argument that the internet is the new public square. 250 years ago, 300 years ago, in the 1700s, the political debates were happening in the public squares. This is a photograph from a postcard of the public square out in Cleveland, 1905, not that long ago. This is a postcard. Found this from an article over on Cloudflare. This is where the conversation was happening, in the public square. This type of speech was protected. This is the free speech. This is the free expression that was taking place. That's not happening, though, today. The internet now is officially the public square, according to Alyssa Starzak. She wrote this in 2017 over on a blog at Cloudflare. Cloudflare is a tech company that provides DNS services. We use them here. Provide a lot of services, actually. She wrote in this article, the Supreme Court issued an opinion confirming something we at Cloudflare have long believed. The First Amendment protects access to the internet. Using sweeping language, Justice Kennedy compared internet access to a street or park, saying, quote, essential venues for public gatherings to celebrate some views, to protest others, or to simply learn and inquire, and concluded that to foreclose access to social media altogether is to prevent the user from engaging in the legitimate exercise of First Amendment rights. So there's some framework there. These are things that are very important. And most of the conversation now is taking place on the internet. These are some statistics over from Statista. And you can see here, although average time in minutes, now this is a global number if I'm not mistaken. This is the data. Mobile time on the internet is going up year after year after year. 2021, it's expected to be 155 minutes on the mobile phone, on the internet. And this is a global number. I think that's probably a lot higher in the United States. Desktop usage is going down, as you can see, but the rest of people are on mobile. That's a low number, I think. 2.5 hours. When I look at my screen on time, it's a lot higher than that. Don't want to admit what it is, but it's a lot higher than that. Okay, and most of that is happening because I am reading the news, I'm participating in the news, I'm thinking about what to talk about on this show, and we are talking politics. We're talking life. It's the public square. It's taking place on Twitter and elsewhere. And this is just trending up and up and up. Add COVID into the mixture, the COVID lockdowns, it's even more important now. More things are going digital. Courts are going digital. We're making court appearances. We used to have to go down physically to court all the time, going on Zoom. Access to the internet is becoming more and more important over time, not less. Protections are more essential now than even last year because there is no alternative. There is no public square. If you wanted to go out there and host a rally like you saw in that photograph, you're not allowed to do that right now in most places because of COVID. The only alternative now is to go online. As I mentioned, simplicity, I think, is very important with this digital Bill of Rights. Let's take a look at the preamble to the Bill of Rights because we want to model some of this. The preamble to the Bill of Rights, this is all, basically explaining what happened and why they did this. The conventions of the states, they've adopted their constitution. They expressed a desire in order to prevent misconstruction or abuse of its powers. They want further declaratory and restrictive clauses to be added. These are the articles that they went through. And now some proposals that I've seen on the internet are long, right? Pages and pages of documents. This is what the Bill of Rights looks like. This is the entirety of it. Okay, you can fit it all on one page. First Amendment, second, third, fourth, fifth, sixth, seventh, eighth, ninth, and 10th. And now I'm not going to read through all of them, but what I did, just for the sake of brevity, is I summarized them. So First Amendment, what I did is I numbered the amendments, and you can disagree with some of this if you'd like, that's fine. I numbered the amendments, gave a clear sort of quick description of them, and then identified what the liberty interest was. What are we trying to protect? What is important here? First Amendment, freedom of speech, press, assembly, protest, redress of grievances, and religion. What are we talking about? The liberty interest is expression and participation. Just the general. Keep and bear arms, personal protection, quartering, autonomy, protection against intrusion, unreasonable searches and seizures, privacy rights, private property rights, due process of law, just compensation. The government can't take your property without compensating you with just compensation, grand jury proceedings, double jeopardy, protections for the accused. Same for Amendment 6, 7, and 8. All protections for the accused. We have speedy and public trials, impartial juries, right to counsel and witnesses. Jury trials in federal cases, excessive bail and fines, and cruel and unusual punishment. All sort of due process claims. 9 and 10, all of the rights are reserved to the people. If it's not enumerated here, if it's not enumerated in the Constitution, it's not listed here, it goes back to the people. The people are sovereign against the government. Federal government limited to enumerated powers, sovereignty of the people. So when we're thinking about this new Bill of Rights, we can just model this. It doesn't have to be all that complicated. What do we want to do? We want to focus on protecting expression, participation, personal autonomy, prevention against intrusion. We want to protect due process. Before you deplatform and throw people off the internet, maybe they're entitled to some due process because the liberty interest is so important because it's part of the public square. There's nowhere else to go. If you're deplatformed, you're being denied your ability to participate in the country practically. Not legally right now, but practically you are. And I'm empathetic to the argument that they're private companies and they're free to do what they want, but so were a lot of other private businesses back during the segregation era, right? Those are the same arguments that they made. Hey, it's our business. We can do whatever the hell we want. And we said as Americans, no, you can't, okay? You can't do that. It's not separate but equal anymore. You are not allowed to send one group of people over here and another group of people over here. Why? Because we as Americans don't want that garbage happening anymore. It's wrong. Civil rights movement, fix it. Still working on it, but you know, right? It's a work in progress. And this is the same concept. Currently, we're in an environment that doesn't feel quite right. Doesn't feel like it's in synergy with some of the fundamental liberties and principles that we hold dear as Americans. So we can model the existing Bill of Rights, apply it to the digital era. So let's get into it. The First Amendment, the first digital Bill of Rights, the digital freedom of speech. And so this is what I wrote. I wanted to keep it simple. You're going to see it's very simple here. The internet, big I internet, shall have no laws abridging the freedom of speech, expression, or of the press, or of the users, big U users, to peaceably assemble on the internet. Okay? Very, very similar to the first Bill of Rights. Doesn't talk about religion, doesn't talk about petition to address the internet for a redress of grievances or any of those things. Big I internet, this stuff would be defined by the courts, by the legislature. It would be codified at some point. It would be interpreted, just like the First Amendment has been interpreted. Users is the word that I came up with to talk about users. But you could use people. I just use users for clarity. And so you can just start to balance this out. It's pretty big, pretty broad. Peaceably assemble. You want to be a part of a group, you want to go on Facebook and be part of a group, and you're doing it peacefully, got to let you do it. If they want to censor you or delete your content, they can't do that because you have an absolute right to the digital freedom of speech. That's number one. A lot of pros and cons on that. Now, as I said, don't want to be overly burdensome on the big tech companies. I'm going to explain what their protections are in Amendment 8. The way that this is going to work is, as long as they're operating within the bubble of liberty, within the digital bubble of liberty, as long as they're adhering to the first 7 digital Bill of Rights, they get protection from the 8th. It's called good faith protection. And I'm going to explain what that works like, what that looks like. So the first response to this is probably going to be, well, what if you have people saying bad things on there? What if you have people saying dangerous things? I think that's something that we have already litigated a lot. We've already talked about what is free speech and what is not free speech. Those same rules might apply. Now, they are setting the bar much lower currently. They're saying if it's dangerous at all, according to whatever definition that they want to come up with, that's enough to eliminate this. This would be raising the bar. It's got to be closer in alignment with what is already considered to be not free speech. We already have a framework for that. We've got legal precedent for that. Amendment 2, the right to digital personhood. All users shall have the right to exist in their true identity on the internet. Once again, big I internet. That means anything. Okay, DoorDash, Pinterest, Facebook, Google, and all of them. And all users shall have the right to exist in their true identity. Now, I put true identity there because if you want to participate in this, you got to identify yourself. Okay, you don't have a right to get on the internet and participate anonymously because I'm mirroring the public square argument. Okay, you could go stand at a public square, but at least your face is there. At least somebody know, hey, is that Rob over there? Yeah, that's Rob. Right? You're participating. You have some skin in the game in a certain way. Okay, this, I think, this is probably controversial for some people, and they may want to extend this further than that to be, well, it doesn't even have to be your true identity. If you want to be anonymous, you can be anonymous. I'm trying to balance some of these factors, but I'm open for comments on that. You have a right to digital personhood. You can go out there and be a part of it, just like you can go out and be a part of the public square. Public square, now on the internet. If you want to go participate, you want to identify yourself, have at it. And I think, just speculating on this, that people who are identified, people who are speaking through their own identity and not some pseudonym or an avatar or a domain, a sort of a public handle, then it's less likely that they would be needlessly volatile. I think you might just see sort of a natural calming of language. It's easy to go out there when you have an anonymous identity and start blasting everybody for everything. But if it's your name and your identity, it might clamp down on some of that, dangerous speech. Just speculating on that. Amendment 3, the right to absolute deletion. Users shall have the right to permanently remove all data from the internet. Okay, and this is internet, big I. Now, I don't know how you would implement this, but if you as a user wanted to go and delete your Facebook data, I know you can do it. I know it's very difficult to do it, and I don't really know if they actually do it. Right? I don't know if they actually delete it. Same with Google, same with Twitter. If you just want to say, hey, I'm out, it's your data. You have the right to pull it back off. And they should make it easy to do it. That's amendment number 3, absolute deletion. Number 4, the mobility of information. Now, this is probably the most burdensome on the tech companies. Users shall have the ability to move their internet data between providers without impediment. So what I was thinking of here is sort of an open protocol where you would be able to take your followers or your list of data and move them from one platform to another almost seamlessly. And I know that would be sort of a big ask of the tech companies because they would have to speak the same language, right? They'd have to basically create, APIs or something like that all communicated with one another so that you can convert a Twitter follower into a Facebook follower, into a Google whatever, something like that. So you'd have to build out these communication technology. But if you could, by statute, define what that looks like, and you could just go onto one social media platform, pick up your data and say, I'm out of this one, pick up my data, I'm going to take it over to a different platform and plug it back in. You can move things around. Because I think currently part of the issue is if you get booted off a platform, you got to start over on a whole different platform, and you cannot get your data back, even though you've been contributing your data to that platform, which is helping that platform become a profitable, growing entity. You're contributing to it. You should be able to take that and move it around. Don't know how practical this one is. I think, and I would admit, I think this is probably the most burdensome amendment here. Number 5, the right to digital privacy. No user data shall be shared without express user consent given in an intelligible agreement. So you leave this up to courts. What does intelligible mean? Is this 300 pages of a terms of service that nobody reads or has any idea what it means? Right? Robinhood, everybody just learned they can just sell your shares if they want, if you disparage them. Did anybody read that when they signed up for it? Largely, right now, the answer is, doesn't matter. They clicked yes, I agree. Nobody reads it. They know that nobody reads it. It's filled with legalese that's impossible to decipher unless you're an attorney, even if you're an attorney. So intelligible agreement would say, hey, this is what we're going to sell. You sign up for an account on Facebook, we're going to sell your occupation, your name, your location, your profession, all of these different things. You cool with that? It's intelligible. You say, yeah, I'm cool with that. No problem. Boom. I agree. Bullet points, easy to decipher, intelligible. Because right now what's happening, I think, is a lot of people don't even know what they're getting into. We have amendment number 6, the right to unfilter. Providers of internet services shall offer users unfiltered, uncensored, and unrestricted access to the platform at the user's discretion. This is pretty strong language. I think this could be tampered down. I was probably mad when I wrote this. Uncensored, unrestricted access. But here is my point on this. I think that currently the algorithms are set up in a certain way. They want to show you content that is going to agitate you so that you engage with it, make you laugh so that you engage with it, make you sad so that you engage with it. And they're going to limit the reach of certain content for certain purposes, for protection against lawsuits, because they don't want to contribute to dangerousness, because they don't want to be seen as endorsing one political side or another. That's fine. They can keep all of those algorithms. But you as a user, if you just want to go through a raw, unrestricted timeline, you have that option. You just say, okay, show me things chronologically. Show me all my followers chronologically. Let's see what they posted. And that's it. The algorithm responds. Now, I don't know how you would manage this or what the sort of the tech background would look like or how that programming would work. But you could say, all right, I want to sort by the most frequently contacted. I want to sort by the most recently posted. People who are active online right now. Something quantifiable, something that is less about the algorithm and more user experience on what data they are seeing. Because right now what's happening is these companies are acting like filters, and they're showing you what they want to show you. And you as a user don't understand the complicated algorithmic manipulations that are taking place behind the scenes. And you're getting fed information that is not necessarily raw. It's been curated. It's been filtered for you. And so as people who want to participate in the public square, we want to see what else is out there. We want to just have a free, unfettered access to our contacts, to the information. So 6 is the right to unfilter. 7 is the right to digital due process. Providers of internet services shall not deny users access to any part of the platform without affording due process, which must include, and I just threw some ideas on this one, a specific and clear explanation of the policy violation that has been identified. Specific reference to the policy violation at issue. What is the policy? So what is the policy and how did we violate it? Provide a meaningful opportunity to rectify the violation. Provide an opportunity for an appeal to be heard by an identifiable person, a human, not a machine, not a random email. Provide a written explanation upon determination of the appeal so that we as users know. and provide details about other legal options to the users. And so, obviously on this channel, we've been the subject of some of this stuff. We had our chat platform just eliminated. We paid for it, got an email, gone. No opportunity to rectify that. I think there were over 1,000 people in there. They didn't like something. They didn't tell us what it was. Just deleted. We sent a response. Hey, we're willing to operate within your terms. What can we do? We reviewed your account. Our decision is final. Thanks for playing. Gone. Right? And it's not just happening to us. It's happening all over the internet. We just saw this last week. There was a demonetization crucifixion around all of YouTube. It wasn't just conservative websites. I'm seeing a lot of other liberal channels that have all gotten demonetized. And I feel really badly for them. There was one person who's out there saying, hey, this was my entire income. This was my full-time job. I've been grinding content on this thing forever. And I just got an email, no more. Okay, you as a person, as a content creator, you have a reliance on that stream of revenue. We got demonetized. Fortunately, I have a separate day job, so we're okay. But there are many other people who are not, right? And they're leaning on these big tech companies, and they're providing value to them. And they just get the rug pulled right out from under them. I feel terrible for them. It's sad. So maybe some due process before they can take action depriving you of the other liberties that we've defined in Amendments 1 through 6. If they're going to encroach on any of those things, you got to have due process. Identify the policy, identify how you breached it, identify how you can rectify it, give them meaningful opportunity to rectify it, speak with a person about it, tell them about your other legal options. And the last amendment here, amendment number 8, and then we're going to take a look at some questions from the chat over on Locals. The chat will be on Locals. I think I can take a look at YouTube today too. If all of those different amendments are complied with, we just created with amendments 1 through 7, 1 through 6, sort of this bubble of digital liberty that I think people should be entitled to, or at least arguably those things. Before they're taken away, you get due process. And if any of the internet, the big I internet, if anybody in that space is complying with amendments 1 through 6, or removing them through due process after Amendment 7, then they get what's called Amendment 8, good faith protection. Providers of internet services who comply in good faith with the articles shall be immune from liability. Okay, this is basically what Section 230 says. They're immune from liability in a court of law in the following instances. Now, I got specific here just to make a point, but I don't think that the final amendment should be this specific. Okay, transmission of illicit imagery, claims of defamation, offers to engage in illegal services, sale of drugs, prostitution, all of those things. Okay, if the users are doing those things, if the users are making dangerous statements, if they're doing all of that, the tech companies are immune for it. Providers, though, who are failing to abide by any article in this bill are not subject to good faith protection. So you create the little balloon of liberty. You say, as long as you're operating in this, if you're granting more people the freedom of expression, the freedom of speech, the freedom to participate, you're granting them digital personhood, you're following due process before you deplatform or remove anybody, we're going to protect you. Google, Facebook, Parler, Amazon, all of them. You're good. Don't worry about it. But the moment you start censoring people, adding context, reducing reach, deplatforming people, you lose those protections. You lose the good faith protection from the new Digital Bill of Rights. You're now subject to suit because you're violating civil liberties. You're violating civil rights. And this is stuff that I've just been toying around with, kind of having some mental gymnastics, some mental fun about it. I know there are some other proposals that are out there as well. Let's take a look at some chat, see if there's anything in there. All right. So let's take a look. Some questions over on Locals. We've got Farmer's Daughter says, I don't mean to sound like I'm ignorant, but what is quartering? So that's when the British were telling Americans that they could that they had to accept troops into their residence. So the English troops would be quartered with the colonials. Chris Wiseman answered that. Chris Wiseman's in the house. Good to see you. We've got Jeremy Matrita says Facebook is digital slavery. Makes sense to not give bots rights. Yeah, so bots would be important. Dangerous language definition should be based on similar analogous doctrine such as true threat. So C. Wolf says that. Compatibility is a tough one. Yeah. Programmers have a good challenge coming from C. the Evil. We have Chris Wiseman says, I believe SCOTUS has established a right to anonymous speech. I would recommend taking the approach that digital and physical mirror each other as close as possible. We should not have two tiers of speech. That's what we're trying to rectify now. Yeah, so that's an excellent point. Sharon Quidney says, number one is perfect. Number two, a person has to be able to protect their privacy. But you have a good point that if people actually knew your real identity, it might make people more careful, more aware that they're in a public forum. But wouldn't that expose a person to danger as well? Yeah, I think that's a good criticism of that. You know, anonymity, I think, is a good one, right? Because a lot of the founders were sort of writing under pseudonyms. They weren't actually using their real names. So the anonymity thing may be something worth exploring again. Jeremy Matrita says databases are transferable. Sharon likes number 5. Jen says like smart switch for phones, pictures, or contacts. Google Translate, number 5 is huge. 5 is a challenge. 5G doesn't give us permission to control or know who owns our data, buy or sells our information. Ooh, that's interesting. Through JSON or XML, the data is easily accessible. Most of the standards are already defined, from John Kreutz. Chris Wiseman says the right to portability is recognized under both the California Consumer Protection Act and Europe's General Data Protection Regulation. There you go. See, so there's some foundation for this. Sharon likes number 6 as well. YouTube just started purging Democratic channels this week. That comes from See the Evil. Yeah, I saw that. Everybody's getting demonetized. Yep. Konovac is gone and several others. Farmer's Daughter says 7. Let's see here. Yeah, okay. So number 7 is so commonplace now. You are speaking for millions. Yeah, due process. Sliding Edge says, happy Saturday, Robert. Liking the topics, the new venue of access, and of course the discourse that we engage in. Keep kicking butt. Thank you, Sliding Edge. Thanks for being here. Britt Reed says, I have some minor disagreements, but this is a great starting point, Robert. Thank you. Good, good. We want some disagreements because we need to sort of hash through some of this. I tried to warn some of my den friends, if they do this, anyone will do it. Number 8, I agree with you. It really shouldn't be specific, but it should be like that 530 protection. I think you mean 230. We have Jeremy Matrita says, how about we get political beliefs added as a protected civil rights group? Yeah, that's another good way to do it. So Chris, Ma Fox just chimed in, says here, added this, says, incorporating freedom of speech against corporations isn't what you want. It's also not what I would want in the slightest. You're attacking the symptoms and not the actual underlying issues themselves. Rather than promote market growth and smacking companies that constantly buy up competition and have overwhelming control of the market, you're instead saying that any conglomerate company can't do what they want with their property. Now, if you're talking about control of the internet infrastructure, I could probably agree, but not in this case. This is giving us more centralized government, which is something I see as extremely troublesome. Private property, unless the government deems otherwise, is something truly concerning of a mindset for myself. Just imagine this mindset being promulgated by anyone with malintent. What would the line be? Would that line be set in stone? Would it change over time? Would it change due to political leans? Let's say I invite people over to my personal property to hold a political rally, and these people start spewing off rather disturbing rhetoric, and I want to remove them from my property. In your idea, the government should be able to tell, nah, you can't do that. They have rights. Well, what about my right to my property? Is that just gone now? Yeah, that's a very important point. I'm all for antitrust laws, but this is giving scary powers to government to control companies, and I don't think people would realize the potential repercussions for doing this. Broad powers like this do not remain innocent for long in the real world, and they become more broad over time. Stopping companies like Google from buying up competition is a potential solution to a freer market for the internet, but again, the government taking control of a company is absolutely unfathomable to me. Well, you're a big company now. Know what we're the government going to do? We'll just call you a public square, and well, sorry, mate, too bad you've been successful. But them's the ropes. Yeah, so Ma, I think that you wrote that. I think that's an excellent point. Very good points. I am, a libertarian also-ish, libertarian-ish. I would say I'm closer to that than anything. And I do have some concerns about passing laws that will tell the government that they can go in and take over a company. But I'm trying not to kind of do that right now. I'm trying to say that these are civil rights. These are civil liberties that we want to see embodied. They're already embodied in America, right, throughout our culture. And we just want to apply them in the digital realm. And so what's the best way to do that? So I'm not saying that the government has the ability to go in and modify these. So basically anything else that's not enumerated here would be reserved. You know, there's nothing. I'm not trying to give the tech companies an active obligation. There are some active obligations in here. I understand that. Things would have to change and modify a little bit, but I don't want to see sort of a revolving door of regulation. I just want to set a baseline standard and say they can't drop below that baseline. But it's a good point, right? Any type of regulation has a lot of potential for slippery slopes and just an encroaching government. And I am extremely cognizant of that. But I think you can look back in history and say, well, you know, we've balanced that well-ish, right? I mean, we desegregated, we opened up the schools, we've kind of gone through some of these issues historically, and we've just said this type of, you know, if you're a restaurant owner back in the, you know, segregated South, they're probably making that same argument, saying it's my business. If I don't want to serve that demographic, I'm not going to serve that demographic. And we as a country just said, no, that's not how this country is going to work. Yes, you are. You are going to serve that. You're not going to do segregation anymore. And I think we're better off for it. And we don't, you know, we don't necessarily see that I think is being overly abused by the government. But it's a good point, Ma. Thank you for that. What else do we have here? We have Shades, _Shade says, Robert, people say they're a private company. They are not. Deep dive into roots, history of Google, then Facebook. They were both central origins of internet control, real history, not the Google search silver plate. Both created, funded, ran by DARPA. Zuck Boy is a front man. In war games, you must know thy enemy completely to win and outsmart them. Yeah, I'm somewhat familiar with some of that, Shades. I think I agree with you that these are not necessarily, you know, private companies. They're plugged in. We saw a lot of the stuff from the Snowden leaks. They've built back doors for the government. They were just letting them siphon off the data. I mean, they are using, you know, there's a series of cases in constitutional law that surround the Commerce Clause. And it's some of the most infuriating case law that you ever saw. But there was a series of cases, I can't remember what the name is, where they were basically telling farmers that, you know, they couldn't farm anymore, or they had to farm more because they were selling their grains across state lines. Now they're engaged in interstate commerce, which gives the federal government the ability to regulate that now. And so they passed all these regulations on farmers and subsidies and all this stuff. And you're going, wait a minute. Just because you sell a widget that might be sold across state lines, now you're subject to federal regulation. It was a massive expansion of the Commerce Clause power. Massive. Disgusting in my opinion. Unconstitutional in my opinion, but they did it. And so now these tech companies that are using, you know, the internet, which is a public good in my mind. I mean, we are using the telephone poles, the fiber optic cables all across the internet, all across the country, physically across the country in data centers and warehouses, and it's transferring across state lines. So it's kind of not really a private company. It's also not a public company. It's not a government either. So it's in this weird sort of amorphous category. See the Evil says, LOL, see the veil, or see the veil. Sorry about that. See the veil, not see the evil. Farmer's Daughter says, anonymity is a double-edged sword. How will anonymity work in the real world where there is a limit to the number of name changes one can have? At least there is here in Missouri. Yeah, good question, Jackalia. Not sure. See the Veil says, depends on the company. Some platforms allow many users' names. _Shade says, back in the day, we had a phone book with white pages. Everyone's phone number and address were listed. LOL, people forgot about that. Yeah, I remember that. I remember looking at the white pages. Steve-O, 9300 says, well, let's assume the powers that be would like it this way. They are the ones that hold the power. What would motivate them to take this on? I think it's the people that would have to do this. Yeah, I think the people would have to convince their legislators to do it or support a constitutional convention. Sarah Smothers says, I honestly think some sort of regulation on the internet would be good for kids. Restricting anonymity can create more civil conversations, and people are more likely to treat each other like they would in person. Perhaps less youth suicides and, quote, grooming may take place. The internet is the next frontier, and it can be quite the wilderness. S. Crutcher says, very good. Unbiased search engines. Yeah, that would be good. True. How will any of it be enforced if the people with power don't do it? Yeah, another good question, right? How do you enforce it? So I think to answer that one, Paula MK, I think the answer there is the lawsuits. So if they're breaching the first 7 amendments, then they don't get the protection of the 8th. They don't get that good faith protection. And then you just sue them. You say, all right, they violated Amendment 1. They limited my free speech. I'm going to file a lawsuit. Right now, you can't really do that. You can, you're not going to win it because there's no claim. They're protected against liability from Section 230. So by basically lifting the floor up on the civil rights, currently there are basically none of them. No civil liberties as it relates to digital public square. So you lift those up, and that would be a new claim. So you'd have a number of individuals just suing them. And that's a pretty good compliance methodology. Jack Elias says, governments already have the authority. Where'd that one go? All right. So we have Jack Elias says, governments already have the authority to take over a company. I have seen housing complexes taking away from the owners and given to others to manage because they failed to keep drug dealers out of that community. Yeah, they do. There's some eminent domain stuff going on. What you're saying about baseline and keeping government interference at a minimum sounds like number 9. Yeah, I think we could probably flesh out 9 and 10 for sure. Chris Wiseman says, what are your thoughts on the idea that an internet company must define its existence as either a platform or a publisher? Platforms are subject to viewpoint neutral public square protections, while publishers are entitled to editorial rights, but then assume liability. So I think it's just a different way to get to sort of the same conversation that we're having. It's using some of the existing legal infrastructure to reach the same conclusions. I mean, yeah, it's sort of the same thing, right? If they followed all of these 8 amendments, then they would be considered platforms, right? They would be considered platforms. They would be public square. They would be neutral because they're allowing people in. But when they start limiting, then they lose the section of the good faith protection for amendment number 8, and then they get subject to liability. So I think we're kind of talking the same thing. We're just reaching it through different mechanisms. Ma Fox says the government can create the digital space themselves, like private and public healthcare working together. This could be another potential alternative as long as the government couldn't buy up competition or shut down competition. So you're kind of talking about nationalizing the internet through the government. Yeah, that's an interesting perspective. I just think that the government's not any good at it. So you kind of want these private companies to do it, but you just want to lift the floor up on what they're allowed to boot off of their platforms because there's really no place else to go. Keith C3 says, in response to Ma's analogy, these platforms wouldn't be the resident or the tenant. They'd be the landlord or the lien holder. The user would be the resident, and they should be the ones to kick the person out of their barbecue. It's a good analogy there, Keith. Farmer's Daughter says this is true with big companies. One corporation owns all the corps. Landlords have the ability to kick out problem tenants and their visitors. Ma's responding. Just XUXA says, look into Nevada allowing digital companies creating their own governments. So I saw that headline today. That basically they're allowed to buy up land. They can form their own schools. They can form their own governments. They can start their own police forces, all that stuff. Key C3 says the bank that has the mortgage can't come over and tell you who to root for at your Super Bowl party if you're allowed to have one. There's always a need of change to ensure protection. Bernadette C says, absolutely love that you put this together. Thanks, Bernadette. Having fun with it. We got John Crute says, libertarian point of view is that I, as the individual, have the right to allow when or if the corporation is using my children's information and exactly how and when they're using it. Yeah, so John Crute's another libertarian-ish stuff. Chairman of the board says, this is great stuff. You hit on one that I was thinking about last night, the right to take your data and move to another platform. I liken that to when they ruled that phone companies had to allow you to take their phone number with you when they switched. It was a total game changer. That's right, Chairman. I forgot about that. That's a good analogy, right? So you're not locked in. More freedom. I like it. Jeremy Matrita, good to see you, Chairman. We have Jeremy Matrita, who says, one of the most important things to consider is to never allow, where'd that go? Chat's moving around. All right, Jeremy says, one of the most important things to consider is to never allow something like net neutrality. The internet is a communication network made up of private and distinct individuals and companies connected together. We never want to treat it as a utility. Our greatest power at the moment is to have the ability to take our business somewhere else. The biggest shock we experienced in the last few months is when big tech did things we never saw coming. Yeah, I mean, a lot of people are really, really, screwed right now. And it's a sad thing. Jack Elias says, I know my state level representative and senator are interested in this. Cool. John Crute says, hence anonymity for myself and my children. So that was the point of his earlier statement where he's saying, basically he has the right. I'm open on the anonymity stuff. Key C3 says, and the tenants and visitors in theory would need to commit an actual crime or violate the lease, which could fit into your argument, swapping the lease with the EULA. However, the bank couldn't do this easily, and we're paying a mortgage with our data. On a sarcastic note, how can we achieve the right to bear digital arms? It's a good question. It's a good question. What are those? Memes. You got to have memes. We should probably make the Ninth Amendment freedom of memeing, because we've already seen people are getting arrested for it. You want an arsenal of memes. You want them organized. You want them ready to fire. That's the right to bear arms. You want the spiciest memes that you can come up with. That's like the Second Amendment. Chris Wiseman says, how can we balance rights of association, including the right of exclusion, with speech? These are both recognized under the 1A, but I think it's very dangerous to cede rights of association in favor of speech. I think that utility common carrier platforms should favor speech over association, where private companies like locals, personal homepages, blogs should favor association rights over speech rights. Yeah. See, these are tricky things. Now, this is where you'd have to get into the weeds a little bit. So I think like the first principle, the underlying concept is that you want more freedom and you want more free speech. Now, how do you implement that? If it's a paid platform, so some of the incentives that I was thinking of, or some of the ramifications of this, is what if you just have other people just saying, okay, well, if this is regulating the internet, we can't do business there anymore. So what we're going to do is just create our own version of an internet, right? We're going to create Internet 2 or Internet 3, and we're going to say you can't regulate us there. Then they're just going to move. I don't know if that's a reality or not, or, that they would sort of try, these companies, we certainly don't want them to go away. They provide a ton of value, whether you disagree with their free speech policies or not. I mean, I think it's unquestionable. They've transformed how we do things for the better, many of them. So how do we protect them and make sure they don't go out of business? If you were to impose this, would that bankrupt them? Would they be totally out of luck? I hope not. That's not the intention of any of this. The intention of this is to give them more protection. Right? If right now they're all freaked out about incitement and dangerous language and all of that because of potential liability or because of their social responsibility to the world or whatever that looks like, we want to give them more protection. Hey guys, don't worry about it. Nobody's going to sue you as long as you're operating within these boundaries. You're good. Just keep moving away. All you got to do is just raise that bar a little bit. You know those people you were trying to kick off for stupid reasons? You can't do that anymore. Okay? The same free speech principles apply. As long as that person could say that in the public, they can say it on your platform. Now, how that works out in practice, I don't know. Maybe locals, because it's private and you got to pay for it, maybe they're less favored by the courts. But I think this stuff would get flushed out in time. It's good. It's a good point, though. Right? I really don't. I don't have a good answer for that, Chris. Good question. Woodworking Medic says, it blows my mind that a certain company demonetized you, a criminal defense attorney, and didn't give you any reason for it. They are for sure a publisher when they moderate content based off of what they don't like. Yeah, that was YouTube. I don't know what it was. I don't know if I don't think that it's even a political thing anymore. I'm hearing more and more that it might be just about some of the things that we talk about. So it happened right after, it happened with everybody else, but I think that it has to do with, I think they're calling it camera violence. So if you show, the 9-year-old girl getting pepper sprayed by the police officer, that's not okay. It's too violent. And we showed the whole body camera, basically. We ran through the whole thing. Same with Daniel Prude, George Floyd, Breonna Taylor. We showed a lot of body camera. We showed a lot of the Capitol Hill stuff. And I think anybody who was in that category got demonetized, liberal or conservative or libertarian or mainstream or whatever. Jack Elias says, I'm late because of a power outage. What special protections are going to be in place to advocate for children? I missed that category. Do we need any? Will minors have additional rights or custodians and guardians additional obligations in this regard? Jackalaya didn't put anything in there about children. I wasn't thinking of the children, but maybe we should need to. Sharon Quidney says, I'm also more of a libertarian, so the less government is involved, the better. I agree. See the Veil says, the ISPs need to be considered a utility and platforms to be qualified as a publisher. We must prevent digital companies to have their own government. There will be no law but theirs if they succeed. Farmer's Daughter, you're correct. With Facebook and Google, who owns them? These owners typically use CEOs as frontmen or salesmen. Chris Wiseman says, whenever passing any law, it should be remembered that a government big enough to give you everything you want is a government big enough to take away everything that you have. Quote by Thomas Jefferson. Shade says, if they aren't public or private, then they are a hybrid, which needs to be defined unto its own. Once it's defined, then could we not make hybrid rules for them? We could, but I just don't know. That would be a big undertaking. So what we're trying to do here is define the base level. Okay, what does everybody have to comply with? Set those base standards and then figure out how to actually implement it. Keith C3 says, I should say, though, that I'm not completely behind these as constitutional amendments, but as a list of requirements that we as users, quote, demand that they agree to, otherwise they don't get our business. Yeah, that's another way to do it. Doesn't necessarily have to be a constitutional amendment. And that is a tall order. I mean, I'm not under any illusion there. Ma says anonymity rights already exist. Anonymity adds to bullying too. Not sure how we can eliminate anonymity though. On My Knees says, should watch this guy's testimony would give insight into how to regulate the government having all the access. Keith C3 says, think about free checking or free long distance, unlimited calls and text with no roaming and cell services. It just takes one company like Washington Mutual, rest in peace, to make the others follow. Yeah, that's a good point. On My Knees is linking over to Robert Epstein. Looks like here he's a senior research psychologist for the American Institute for Behavioral Research and Technology. One video on C-SPAN. Maybe take a look at what he's talking about. Ma Fox just chimed in. Here's your digital Second Amendment rights. This is a rifle. This is not a handgun. This is a handgun. This is a machine gun. Short barrel rifle. Yeah, that's right. So just load that in your meme folder. Let's see what else we've got. Jack Elias says, I disagree. Prior to COVID, there were 18 million incorporated private entities in the U.S., 38,000 incorporated government entities. With the media focused on every government mistake, if 99.79% of the news was about the mistakes made by private industry, equal time per entity, no one would trust private industry. See the Evil says, back in the day, we had books being banned from high schools, junior colleges pulled off the shelves from universities. We all warned back then, if cancel culture can do this to our books and libraries, how long before they started on the internet? Well, we're there. On My Knees says, Robert Epstein also has great solutions for transparency and algorithm options. Cool. I'll check him out then for sure. Kenny 1B says, an analogy to that of a utility is better than that of a publisher. The internet is a utility and the platforms are service carriers. Can Verizon or T-Mobile terminate your service if they disagree with what you were saying using their service? I don't know. I don't know if they can. Probably. I mean, in today's world, probably they can. I would suggest that the right to bear arms has to do with the right to know the protocols and procedures and the codes, a right to the white hat hack sunshine law type exposure. Would means be protected under free expression, free speech? Well, we're going to figure that out, Jackalaya. Somebody just got arrested for that, facing a maximum of 10 years. And yeah, the right to bear arms, I think when I was going through this, I was considering that to be your right to delete. So in all candidness, I actually did think about the right to bear arms. And I was thinking about what is your defense? Okay, if the right to bear arms in the physical world is to defend yourself, then how do you apply that digitally? And my first thought was, if you're under attack, you're free to remove your stuff from the internet. That's the absolute right to deletion. For the internet, that is sort of their ammunition. That is their property interest. They have your data. And if you want to protect yourself, you have the freedom to remove that. If you're under attack on the internet from whatever, you can just say, okay, I'm going to remove it. Facebook, you have my data. I have an absolute right to delete it. Delete it. Now, I don't know how that would spread now, right? That's a perverse incentive. So now what happens? You don't want to open up this ball of litigation. What happens if somebody takes your video that you made where you said something stupid, like I have many times, and they cut it and they post that elsewhere? Do I have an absolute right to have Twitter proactively delete that? Go out and find those references and delete it? I don't think so. That's kind of a big ask, right? That they'd have a compliance department the size of a mega corporation in order to comply with all of those requests, unless they can do it digitally. I don't know if they can do that. I think there's a right to be forgotten law that exists over in Europe. What else do we have? We have Jackalia. These rights need to be defined, argued on the foundation, which precedes the existence of the internet. They have to be unalienable rights, which governments are obligated to secure for citizens, not privileges which governments have a right to remove when convenient to them. Yeah, we sort of, these were all based in the original Bill of Rights, or starting in the Bill of Rights. Bernadette C. says, showing expression of truth is too much for them. They believe censorship is the only answer. Very centered politically myself. I was very shocked they try to silence you. Thanks for sharing what you do. Thanks, Bernadette. We have Woodworking Medic says, do you think your Bill of Rights would have the protection such as what the EU does with the right to be forgotten? There it is. Especially with minors. People are digging up posts from me and such from years ago to get people canceled. Yeah, I kind of think that is included in the right to delete. Jeremy Matrita says, have you gone through the terms and conditions to see if you have legal remedies? Big tech has drawn a target on themselves. Now is the time to punish them either legally or monetarily by creating a competitor that won't treat their users like insert big tech company. The market is definitely ripe for grabbing market share against them, just as the news media market is showing. Yeah, so I haven't really looked into legal remedies. So let's say that all of these got implemented and you wanted to file a lawsuit against them. What would the remedies be? Monetary damages, injunctions in order to put you back on. So let's say they deplatformed you without due process under the 7th Amendment. They lose their good faith protections under the 8th Amendment. You file a lawsuit. You say they denied me my freedom of speech under the 1st Amendment. No due process under the 7th. Lose it under the 8th. Great. File a lawsuit. What's the damage? I don't know. Did you lose money? Then you could ask them for damage. You could ask for punitive damages, just like we're seeing from Dominion and some others. You could ask for an injunction so that they just reinstate you in lieu of damages. There's a lot of frameworks that I think you could work through. Shades over here says, YouTube, Twitter, etc., they deplatform people because you guys support critical thinking and teach people or offer free speech for others. So you're a threat. They don't want that, though. Commies. We'll take a couple more and then we'll get out of here on this Saturday. We've got access to expression coming from XN Drew. Access to expression may be expressed as a basic human right in a digital age. This is the only way some people have community. Having a sense of community is a basic public good. I agree with you, XN Drew. Yeah, we want more people to participate. See the Veil says, correct. The books that were pulled were critical thinking books. They were used in critical writing courses, broadcasting classes, PR classes. Ma Fox says the fair use doctrine suggests that one's data in certain applications, for example, critique, would be quintessential fair use. Jeremy Mitra says, what I meant above in my comment is remedies for your channel being demonetized. Oh, well, Jeremy, that's what Locals is for. Yeah, there's no remedies for us. I mean, I think that it's a voluntary program. The terms of service, like I mentioned, are just massive, and they're free to boot us out of that. So we're not going to be, filing a lawsuit or anything like that. Like it's just how it is. They remove you. It's their platform right now. They're entitled to do that. Kenny 1B says, since the platforms ultimately use physical infrastructure funded through federal grants and taxpayer resources, can Title VI of the Civil Rights Act be invoked? I don't know. I would imagine that somebody probably has tried that. I'm very curious to see what Steven Crowder is doing with his lawsuit. Key C3 says, ironic that Section 230 gives very broad immunity to these platforms from criminal and civil penalties, yet they instead choose to censor and curate. Reminds me of when prosecutors gave Sam Giannana immunity against his will so that he couldn't plead the Fifth. He still refused to testify and serve much time for contempt. Maybe not a bad template to follow. Jack Elias says, having been in Army intelligence, the weapon of war in information is exposure of information. I would apply that to the right to bear arms concept. The equal and opposite obligation Rawls style would be, when does one have the right to redemption? Is cancel culture the digital equivalent of murder? Wow. That's heavy. I mean, for some people, yeah. Right? I mean, it's not the same thing as murder, right? Nothing's the same thing as murder. You're not killing somebody. But you're seriously harming them. If they don't have the ability to participate, that's a big problem. Woodworking Medic says, do you think the lawsuit in New York about Dominion voting with the counting will have ramifications for all other people who said the same thing? It's rules for thee, but not for me. When you told us about that lawsuit, my jaw dropped. Yeah, I don't know. I mean, I don't think it's going to have any ramifications on the current political environment, but it is interesting now that they're using the same arguments that many of Trump's lawsuits used. Chris Wiseman says physical utilities are being treated as hybrids. In exchange for being given monopoly-duopoly position, they cannot discriminate for the purposes of viewpoint discrimination, so quasi-government entity. And he's referencing over here, Telecommunications Act. Yeah, there are some other ways to, I think, affect some of this stuff. Net neutrality, Communications and Decency Act, we've talked about on this channel, established immunity from liability for third-party content on the grounds of libel or slander. The DMCA, the Digital Millennial Communication Act, established that ISPs comply with the DMCA would not be liable for copyright violations of third parties on their networks. New presidential administration, the FCC reversed its own rules on net neutrality, essentially revoking common carrier status as a requirement for internet service providers. Yeah, so there are a lot of provisions out there. Your right to free speech doesn't come with a right to venue. Think that through. From Zulu on YouTube. Thank you, Zulu. Yeah, and that's an interesting argument, actually, that I've seen floating around. Right, you have the right to say what you want, but you don't have a right to say it where you want. So I think Zulu's sort of taking back to, I don't know, maybe some time, place, and manner restrictions under the First Amendment. So some limitations on some of that speech. I'd be curious how Zulu would extend that into the public sphere. So how do you distinguish between those two? Are you not allowed to go into the public space in the physical world? Do you not have a right to that venue? The analogy here is that it's sort of the same venue, or it's sort of the same concept to a public forum. You have to have access to a public forum. Otherwise, that's a limitation on your freedom of speech. What good is free speech if you have nowhere to say it? I guess is the point. We got Ma Fox says, yes, shout out to, oh no, that's Keith C3. Shout out to Quintessential Fair Use and the victory in Hughes versus Benjamin. Farmer's Daughter says, very educational. Thank you for the ability to disagree intelligently. Have a blessed Sunday, everyone. God willing, the creek don't rise, which is unlikely since it's frozen. All right, well, stay warm over there, Farmer's Daughter. We're going to wrap up here soon. Let me just get through a couple more of these. I remember when AOL from Sliding Edge, AOL, Skype, Facebook, and the like were reported to have acquiesced to the government's request to put their own servers in the said company's server's room. Having access like that blurs the line between private corporations and government entities. Shouldn't that affect the reach of the Freedom of Information Act into said corporations as a type of extension of the government? Either way, a bit of a stretch, but where does the First Amendment place among large platform entities? Where does the First Amendment place along large platform entities? Matt Maker Jenny says, great show tonight. Keith C3 says, that would apply to more, for instance, the government not being obligated to buy you a camera and mic. Okay, yeah. Jeremy Mutrita says, I love your efforts and your ideas. The live stream is a perfect example of how ideas should be absolutely be debated, tossed around, and considered. Thank you for the opportunity to participate in such a great discussion. The freedom of speech is the right to improve our community. Thanks, Jeremy. Zulu says, a privately owned public forum. Got it. Okay. Seawolf74 says, how about modifying Section 230 to include these limitations? So I think you could do that. Jeremy Crute says the counter argument for anonymity is not being able to track someone who is anonymous. Through the use of IP metadata, if you are a danger or are performing in a dangerous manner, you can be easily tracked. A simple VPN connection does not hide you as well as you may think. Jack Elias says, how about if a platform is open to anyone to use, as is Facebook? They are a public venue, or only illegal speech by First Amendment standards is forbidden, while they are more or less restrictive if they are a private club behind a paywall, like the old key clubs. Whoops. John Crute says, great show. Appreciate the time you and the team put into the program. That's a good segue to end the podcast. Thank you, John Crute. All right, my friends. Well, listen, thanks so much for taking some time to dive through this with me. I know a little bit different, kind of fun though. I thought it'd be fun to sort of play around with these ideas. Obviously, a lot of room for discussion on this. If it is something that you think maybe we should keep working on, let me know. You know, if you have some ideas now that we have sort of had a foundation laid out, I am absolutely open to continuing the conversation. So if you have anything you want to send my way, everything that gets sent to the tips address goes directly to me. tips@rrlawaz.com comes right into my inbox. I put it there so that it sort of keeps my inbox clean. So send them right to tips@rrlawaz.com. And then maybe this is something we can revisit. You know, have some working sessions on and ultimately draft up something that we can send off to our congresspeople and see if they'll do anything about it. But I appreciate all of your feedback. I appreciate all of the objections. I appreciate all of the support. I think it's a fun conversation, and I look forward to carrying it on. So send any thoughts that you have. Head on over to Locals if you want to participate in the chat next time. Everybody, have an awesome rest of your Saturday evening. Hopefully you're doing something enjoyable. Tomorrow's the Super Bowl. If you're into that type of thing, I won't be watching it, but I hope that you are, and spending time with friends and family, sleeping well tonight, eating good food, and continuing on in this great conversation about America. Oh, isn't that sweet? Everybody, thank you so much for being here. I will see you back here on Monday. We're going to get back on schedule. 7 p.m. Eastern time, 6 p.m. Central time, 5 p.m. Arizona time, 4 p.m. in California. Everybody have a wonderful night. Bye-bye.